This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Yes.
But here he says, I am directed to forward here the copy of orders relating to the National Song of India for strict compliance. But subsequently, moving Haidar would not do. Strict compliance and with the request to issue suitable instructions to all concerned agencies in this regard. Now, my lord, my first point would be, my lord, I am not going into the details of this circular, which is not only, my lord, betraying the history, betraying the national struggle, this is running from hysteria. Where is jurisdiction? Well, under which authority of law he has issued this circular? But if your lordship takes up the constitution,
He has forwarded with a request.
request to strictly implement. What is his authority? How can he forward?
One cannot make request, Mr. Bhattacharya.
Provided I have the authority.
We can also request you don't.
Because he have the constitutional authority. The threats are coming. I am purely on the constitutional issue. Lordship is well aware with that. At one point of time, the issue came up before the Supreme Court when the national song was allegedly not shown respect by some students. That matter went up to the Supreme Court. And here the Supreme Court will not question this. Where is your authority to issue this circular? The legislative field is determined under list 1 of the Schedule 7. Nowhere such authority is given to the judgment upon the constitution law.
Yes.
Kindly come to the 7th schedule.
Now, please show us first the orders relating to national song, which was forwarded by this memo of 28 January.
Nothing is disclosed.
This 28 January, what is the next page? Orders.
That is the detail, what is to be performed. The Bande Matra.
Along with this annex, along with this. So you are in fact wanting that the national song should not be sung.
No. I say national song which was adopted by the Constituent Assembly is the only song which should be sung. They have no authority to vary it. Vary to the extent which was discarded by the national movement. It's very important. Because the Constitution is the creation of national movement. Well, we can't really ignore this. Now, when the Constitution was adopted, it was decided that 2 stanzas, after huge deliberation from I would say best intellectuals of the country, ultimately Rabindranath Tagore took the final decision. And he is the first person who sang this song in a particular meeting. Since that was continuing, now suddenly, after 158th year of the song, initially Lordship is well aware, I have given the history. Bankim Chandra Chattopadhyay wrote these 2 stanzas in one of the newspaper or journals, not newspaper. But he had introduced the subsequent stanzas in Anandamot. And my lord is well aware, Anandamot had created a huge murmur. Respected not by everybody, disputed by everybody, but the nation was concerned about the national unity. In that background, my lord, the conversations went on, discussions went on. But Lord, that would, I will take your lordship later. Lordship need not be troubled now. The issue came up before the Supreme Court on the ground that someone has disrespected the national anthem, which has a higher pedestal than the national song. That is admitted. Now I find that they have introduced a bill in the parliament to say that the national song must be in equal footing with the national anthem. That matter will be challenged later. Now, when this matter went up to the Honorable Supreme Court, Joshua Kadauta, now this is reported in 1986, Volume 3 Supreme Court cases. There, Lordship will find the point I'm just raising, paragraph 10. এটা থেকে বলছি মার্ক করে এনেছি But may I read out?
Yes, Mr.
We may at once say that there is no provision of law which obliges anyone to sing the national anthem. Nor do you think that it is disrespectful to the national anthem if a person who stands up respectfully when the national anthem is sung does not join the singing. It is true, Article 51A of the Constitution enjoins a duty on every citizen to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. Proper respect is shown to the national anthem by standing up when the national anthem is sung. It will not be right to say that disrespect is shown by not joining the singing. Then, Parliament has not been unmindful of national honor. The Prevention of Insults to National Honor Act was enacted in 1971, while Section 2 deals with the insult to the Indian national flag and the Constitution of India, Section 3 deals with that. National anthem and enacts. Whoever intentionally prevents the singing of the national anthem or causes disturbance to any assembly engaged in such singing shall be punished with imprisonment for a term which may extend to 3 years or with fine. But I am not reading the subsequent part. Then kindly come to paragraph 14. Apart from the fact that the circulars have no legal sanction behind it, that there is no law relating to either national anthem or national song. Apart from the fact that the circulars have no legal sanction behind them in the sense that they are not issued under the statute authority of any statute, we also notice that the circulars do not oblige each and every people to join in the singing, even if he has any conscientious objection based on his religious faith, nor is any penalty attached not joining singing. On the other hand, one of the circulars very rightly emphasizes the importance of religious tolerance. It is said that, quote, all religions should be equally respected. Then says the two circulars are to be interpreted as to compel each and every people to join. Well, the circular which is issued by the person having without any authority legal sanction says it is imperative or strict compliance. Then again in paragraph 17, Supreme Court reiterates that this has no legal sanction. Paragraph 17, the two circulars on which the department has placed reliance in the present case have no statutory basis and are mere departmental instructions. They cannot therefore form the foundation of any action aimed at denying the citizens fundamental right. Understand? That particular case, when the Honorable Supreme Court declared that this is no disrespect. If somebody doesn't sing song, it's no disrespect. I am not on that. But my fundamental point would be, Lord, in spite of the Supreme Court judgment staring at the face, what is the authority of the Home Secretary to issue the circular? There is no law, and kindly come to me, Lord. I was trying to place before Lordship.
Mr. Bhattacharya, what interim order do you want from us?
So not to enforce, nothing else. If somebody wants to sing on his own, I have no difficulty. But it cannot be enforced. Let them file affidavit, let them satisfy the court about the constitutionality, but they cannot in the meantime enforce. And that was the statement given by them in another court, that this is not mandatory. That order is also there.
Enforce means then you are speaking for which organization, which has complained that if it is enforced, we will be in difficulty?
What to be
But a
interpreted
public interest
in the public,
activist.
I am an activist.
Strict compliance, if it not done, Mr. Bhattacharya, it will inure to some penalty,
Obviously so.
which will be without jurisdiction according
But after imposing,
you are saying, you are wanting us to stay the operation of this memo.
subject to
Yes, that
condition.
time,
Subject to this condition, if anybody is willing, he may sing. My prayer is limited to the extent that it should.
Bhattacharya, you are an activist. You have brought it to the notice of the court. This circular, suppose if we don't stay, What will be the consequence of the circular? We do not know. Is the state taking any impinging action or retarded or any action against that person who had not strictly complied?
They have not yet dared to implement this. If
Exactly. They have
tomorrow,
not. Now, if they do so,
if they
it is for the person who is affected.
no, that would be betraying the public interest. That will have a amas.
So that Mr. Bhattacharya, you have to show us na, that I issue a circular. I don't. This is a circular not of yesterday. It is of January 2026.
And immediately we came to
Here
court.
in August, you have come before us. An activist has come before us in the month of February.
Therefore,
And
we are promptly before the court, and that's why they have not yet been scared to implement it.
Bhattacharya, why should we stay the order? Suppose just one subject to correction. Suppose by this, if the strict compliance is not done by me, I will be hauled up for the violation of that. There had been no such situation here. So without inviting affidavits, Mr. Bhattacharya, how can we go into the merit of this case and say that you altered that, you have no jurisdiction, you cannot say it is strict compliance.
That's why I was cited the Supreme Court judgment that you don't have any authority to issue this.
We will consider.
Now, if in the meantime somebody, one little girl is taken to custody,
the situation so demands you come with us.
Well, he will suffer, then he'll come.
Who will suffer? This is a activist saying that tomorrow Mr. X will suffer.
Now, the state government,
Presumption, Mr. Bhattacharya.
not presumption, but in the next item 28, state government circular was issued.
Mandatory.
I am just reading out.
Item 28.
Jara.
মুসলিম ছেলেরা মামলা করেছি আমরা
Arguments on the use of may and shall. That if a provision violation provides a condition that it would be penalized, then it will be construed as a mandatory. That situation, Mr. Bhattacharya.
That situation was not there when I moved the petition. The second petition kindly takes up.
Paragraph item 28.
Second petition, the state is not here.
Don't take us to some of the petitions.
No. I read out not what is the circular issued by the state after this petition was moved. The second petition.
Second petition is the representation.
Doesn't matter. This is a matter of record.
What is your, as regards jurisdictional aspect is concerned, you will make your submission. But is there had been any instance that due to alleged non-compliance?
There have been no instances. I am, unfortunately, Lordship, public interest litigations are coming, which are espousing a cause of publicity interest litigation.
Oh.
Now, Millets will kindly see executive decisions.
Query to you is, who had suffered? Has anybody suffered as yet?
Kindly takes up after the petition was moved. Certain understanding was there. Now government has issued a circular 19th May. I am reading out loudly.
That is not for
I am
this petition.
The
challenge is also unqualified apology.
Yes.
I am directed to order. This is by Director of Madrasa Education Board. I am directed to order that in suppression of all previous orders and practices, singing of Bande Mataram during assembly prayers prior to the commencement of classes is hereby made mandatory in all madrasa, government model madrasa, English medium, recognized government aided madrasa, so and so. Do you not feel that this is something which is very serious?
Mr. Bhattacharya, there had been thousands of convention schools, our Christian schools, where all the students are asked to pray to God as regards Lord Amen.
My Lord, I am there. Assembly of God
Millets,
Church.
Don't
12 years I have
take
got.
any institution, Mr. Bhattacharya.
Millets,
This issue was at a very nascent stage.
Millets,
When a particular community of students belong to a particular religion said that why you are asking me to sing certain thing which is in the Christian religion, that is not within mine.
that is the case.
I am one of them, Lord.
The Supreme Court judgment,
Because the social
From
fabric
class
of
one
the
to class
country.
Supreme Court judgment, praying to God and praying to Allah, I am not on that.
Heaven will not fall, Mr.
But
Bhattacharya.
heaven will fall.
Today, if we are asked to utter a course which is not in my religion, what happened? I become a person not belonging to the religion.
My Lord is probably not very clear about my submissions. Maybe because I am lacking communication. I say that being a constitutional authority, you cannot enforce a particular song in variation of which was adopted in Constituent Assembly and thereby introducing communal disharmony.
Yes.
That is the point.
And that is the madrasa say they must mandatorily.
That's the point.
Well, there's a huge bloodshed on this, Milord, at the freedom struggle. That's why I have annexed the entire communication. But what I am saying, let them file affidavit. But in the meantime, Milord, not to enforce this mandatorily.
Sir, what Jawaharlal Nehru written
দিয়া
some words.
আরে ওগুলো
দেওয়া রয়েছে এখানে দেওয়া আছে
If you want us to consider, our query is for strict compliance. If it is not strict compliance, then the follow-up steps will follow. A person may be imprisoned, a person may be beaten up, etc., etc. Beaten up, there will be no circular. Suppose consequences will follow, but there is no consequence determined by the government that if you don't do this, you will be taken into.
Then can you record this?
Just
No, I would invite your lordships to take in queue. Therefore, the government has not decided for any penal consequences. I will be happy.
that we will hear the government, Mr. Bhattacharya.
Now, tomorrow you will.
For an interim order at a stage where you are not being able to satisfy us that this is the consequential measure taken by the government.
Milord, if somebody is taken into custody tomorrow, what we do?
Mr. Bhattacharya,
After having custody, we will come before the court.
not custody. I'm not. Pardon my.
No, I say that done.
Saying, not custody. There are various things, fines, sufferance.
Therefore, I am kindly, Milord, kindly help us to the extent to the community be, Milord, ensured that there is no penal consequence as of contemplated.
We will say that Mr. Bhattacharya has not been able to show to us that any penal consequences has been taken on the basis of
That
particular.
I have-
If there is a penal consequence, come and tell us.
After having suffered,
No, penal consequence
Leave
does not mean
they,
that
they need not declare.
made mandatory.
Because what is happening? Mr. Lordship has seen, Milord, the present situation throughout the country. They will impose threat and then say, very well, go to court. What would happen? My Lord, that's my humble appeal to your Lordship, that yes,
we find substance or contention that as regards this jurisdictional aspect, we find substance prima facie. But Mr. Bhattacharya, in the absence of any consequential steps at this stage, we are saying that you come with an evidence.
let them, I am not opposing affidavit. But the matter is pending since 25. Milord, since the matter was pending, Milord, nothing could be done. But thereafter, I find on 19th of May, circular issued by the government of West Bengal.
19th of
May 26, after the petition was filed. That is a part of second petition.
Item 28.
20. Are you there in the 20?
He's there. He says only state is not there.
My lord, they are relying on from one to another. Here, my lord, therefore, at the very
Okay, you tell us, Mr. Tiwari, what is the government stand?
Yes.
my lord, in my respectful submission first, because so much has been said, my lord will kindly bear me and give me right of.
We are bearing with you.
My lord, I am. My lord, first of all, Honorable Supreme Court has said no public interest litigation should be entertained on the ground of ideology. Sir,
আমি তুমি বলে বলি
ক্ষমা ঘেন্না করে দিন। Please.
No, Mr. Tiwari.
My lord,
We have told Mr. Bhattacharya why we do not want to pass the.
my lord, that is what I'm saying. Now, my lord, then, my lord, and my lord, one more point, my lord, even at the cost of wasting 30
Yes, yes.
My lord, a particular decision of the government by this public interest litigation has been asked to be reviewed judicially by my lords. Can it be done just because a section of citizens prefer one particular policy? I say I want to sing 4 stanzas. Can they restrict me by this judicial intervention? What about that marginalized group or that group?
No, he's not
Well,
saying.
my lord, I am taking serious exception to this particular prayer of interim order. Why? Supposingly constitutes a common man, which has rightly fallen from my lords. I used to go to convent. 12 years of my life, I have said Lord's Prayer, 1 hour chapel, Assembly of God Church. I'm led to a school. I used to come to my mother and I say, Ma, amar bhal lagche na. My mother used to say, Jishu Krishna ke Krishna bhebe, tumi pranam korbe. So what happened? Had I become a Christian? No. Rightly fallen from my Lord. I remember that. Now, my Lord, 4 stanzas or 2 stanzas on the part of constitutional lordship will hear it out. If there is no jurisdiction, it will be struck down. At this stage, an interim order, without going into the root of the subject, where my learned senior friend is relying on several debates. I'm also strengthened with that. I'm not shying away. With all the debates starting from 1937, where this issue was raised, and then we saw direct action day on 1946. Less said the better. Less said the better. I am a sufferer of that. My grandfather is a sufferer of 1946. I have an ancestral house. It is 100 years old. So, my lord, less said the better about those debates of 1937. Now, lordship, come to 1950s debates. I will start from 1950s debates, lordship, and then I will prove. Now, lordship, I will come to the question which has fallen from my lord. Lord, I apologize for my exuberance, but lordship, I apologize. My lord will forgive me.
Mr.
Because
Bhattacharya,
I am that person, that citizen who doesn't want this judicial review. Very respectfully. Now I am that citizen. One person is champion for a cause. I may come as a citizen championing for other person's cause. Then my lords will be overburdened on these policies, ideological debates. I am asking a question to myself, lordship. On these ideological debates, is public interest litigation is for these ideological debates couched in our other, less said the better. Now, lordship, what is the enforceable legal right here? A person coming from the blue, championing for the cause of the entire humanity, who doesn't even try to identify who is wanting it, who is not wanting it. With deepest of respect. Now, my lords, will have to pass an interim order judicially reviewing a particular action just because one section of citizens whose cause my learned respected senior friend is espousing has said that this cannot be done. Then lordship will kindly see just injunction on an apprehension. Now my lords will kindly see the pleadings, as far as this is for interim order is concerned, does not disclose any concrete injuries suffered by the petitioner or any person till date. Any concrete injury? Now lordship will kindly see then where my lords will have judicial review. There is if my lords whose fundamental right is being infringed, my lord, what statutory provisions are being violated, then my lords will kindly see. Nothing with regard to my lord. Then if now coming down to what had fallen from my lords, if my lord kindly sees that page 15 which has been that particular notification, my lords will kindly have a look at page 15 which has been pressed. My lord, it is all the words which has very rightly fallen from my lords. Yes. Everywhere it is may, M-A-Y. My lords will kindly see from paragraph 17, page 17.
Page 15.
15 starts, and then, my lords, the way it is to be implemented.
Part of the
writ petition, lordship.
No, this page 16 is a part of page 15.
Yes, lordship. It's a continuation. Page 15.
The order relating to.
Yes, my lords.
Oh, achha.
Page 15 says, which was placed by my learned respected senior friend, that orders relating. My lord, may I read it?
Yes.
I am directed to forward herewith a copy of the orders relating to the National Song of India for strict compliance, and with the request to issue suitable instructions to all concerned agencies in that. Now, lordship, strict compliance of what? How it is to be complied? That has been stated, lordship, in pages 16. 16, lordship, the entire version. The entire version, where the Bengali version is also there, where you praise the mother goddess.
Yes.
And lordship, then it comes, which is important, is page 70. Lordship will kindly start. Playing of national song. Lordship has got it. Page 70.
Yes, page 17.
Lordship has got it.
Yes.
Now, lordship, here, my lords, we kindly see everywhere, my lords, we have said where it can be played. We have given them an option where it can be played. It is not that everywhere it is to be played. Civil invention on arrival of president. Lordship is getting it, my lord, page 17, Roman 1. My lord has got it. See, we have stated that where it can be played. It is not that everywhere it has been made mandatory. From my lords will kindly see where we have said. Civil on arrival of the president at formal state functions and other functions organized by the government and on his departure from such functions. Lordships have got it, Millet. Immediately before and after the president addresses the nation over all India radio and television. Nothing to do with this petitioner or nothing to be mandatory implemented. On arrival of governor, lieutenant governor at formal state functions within the state union territory on his departure from such functions. When the national flag is brought on parade, the national song shall be played on any other occasions for which special orders are issued by the government of India. Then, Lordship, when the national song is played by a band, the song will be preceded by a roll of drums to assist the audience to know that the national song is going to be played. Unless there is some other specific indication that the national song is about to be played, as for example, where fanfares are sounded before the national song is played, the duration, the role in terms of marching drill. So, Lordship, this is this is what we have said, Millet. Now, Millet will kindly allow me. Millet will kindly come to page 18. What my learned senior friend was submitting, trying to submit, Millet. Millet will kindly come to page 18.
No.
Yes.
Clause 3.
Yes.
Lordship, clause 5, Millet, for specific reason. Sir, apnari chala. In all schools, the day work may begin. What was falling from your lordships? No mandate. In all schools, the day work may begin with the community singing of the national song. School authorities should make adequate provisions in their programs for popularizing the singing, which is a mandate of the constitution. Popularizing singing of the national flag, national anthem, and promoting respect for the national flag amongst. So, Lordship, here what my learned senior friend was concerned, that it as if it was being implemented as a mandatory nature. It is may. Most of the schools are not having now. We are not implementing.
I'm happy. Let it state, but it's not mandatory. I'll go out.
I am going by their petition, Millet.
No, this is your circular.
That's what I'm going by the circular, my lord. What has fallen from my lords. My lords will have seen May. Now, my lords will kindly allow me. Whenever the official version of the national flag is sung, played in the audience shall stand to attention. However, there also there is a, my lord, proviso which we have provided. However, when the course of the newsreel or documentary of the national song is being played as a part of a film, it is not expected of the audience to stand, as standing is bound to interrupt the exhibition of the film. So, my lord, Vijay Amuel is taken into consideration. Vijay Amuel says what? Vijay Amuel says that was a particular society. This was a landmark case in our college days, not in our school days, 1980. What it says that if somebody is standing with respect, he does not sing that song just because it is not permitted by his religious beliefs. So there should be a balance. So that does not mean that it is disregarding or disrespecting the national anthem. Well, that is the crux. It cannot be taken beyond that. But people who are wanting to sing, they cannot be said, striking the balance of Vijay Amuel's decision that no, by an honorable judicial order, it will be struck down also for those people who want to sing it.
Then, Mr. Trivedi, can we say that it is your submission that there is no record to show that it is will be implemented mandatory?
Lordship, it is the statute.
You are placing us that provision.
My lord, this is my lord will kindly see. This is recorded by Union of India in Kerala High Court, my lord, honorable. My lord, that is what I was saying. I was trying to cut the story short at the very outset. Now, my lord, what I am humbly submitting, but my lord, off the cuff, making any submission on behalf of the Union of India. My lord, let us come up with an affidavit. Heavens are not going to fall, and they have not made a case as strong to get an interim order.
No, you are ready to say what is said in page
My
paragraph.
lord will kindly appreciate. ASG, Kerala High Court had proper instructions because there was final disposal.
Oh, it is final disposal.
Yes. I don't want to make any submissions of the cuff, lordships. Therefore, my lord, I am humbly submitting. Issue, though Millard's, maybe it is a part of yellow journalism, we do not know. The order does not say on the same issue, the matter was withdrawn. It may be a part of yellow journalism, therefore, my lord, I am not pressing, but it was withdrawn. The same issue before the Honorable Supreme Court. So, my lord, what I am
So
humbly.
public interest litigation.
Yeah. But my lord, it was since it was withdrawn. Now, lordship, what I am humbly submitting with the best of respect, my lord, let us come up with the proper instructions from Union of India. Well, I don't want to make any submissions before the Honorable Highest Court of Judication of the state of the CUF, being the additional solicitor general. So, my lord, will kindly understand my precarious situation.
Oh, all right.
My lord, what I am humbly submitting. Therefore, my lord,
Don't pass any interim order.
my lord, give us a light of another day to come up with proper instructions, because my lord, we have placed everything. Because the apprehension of my learned senior friend, my lord, from the bar, I can say, is not well founded as of now. Because my lord, Kerala High Court judgment, we have said, my lord, I don't want any recording because it will be coming from without any proper instructions, my lord. It will be not proper for me, my lord. So, my lord, what I am humbly submitting is, my lord, let it be. I am coming by way of a affidavit in form of a report. আপনি তো বলেন অ্যাফিডেভিট করে নিয়ে এসো, ঠিক আছে, নালে কেউ মানবে না। এখন আপনারই কথা বলছি, তখন আপনি মানবেন।
আমি তো বলছি কবে দেবে, আমি মেনেই বলছি কবে দেবে।
In my matter, which my lords have heard, it was only that page 15. Nothing more, nothing less.
It was not there then.
Now, my lord, so that is only with the Union of India. As far as Mr. Majumdar is concerned, he is not involved in that matter. So, as far as that is concerned, my lord, I am submitting, my lord, that prima facie may has been used. One. Secondly, lordship, lordship, because everything, my lord, coming from me off the cuff does not. So, my lord will kindly, and my lord, I have also my learned senior friend is also in truce with me as of now. Sir, উঠে বলে দিন না আমি affidavit.
আর তোমার সঙ্গে তো ঝগড়া ঝগড়া তোমার সরকারের সাথে। বলো বলো বলো, অসুবিধা কি আছে?
রাবণকে মারার জন্য
But this Bande Mataram,
Two cents, nothing.
two minutes. Bande Mataram, this subject was debated in the last year in the month of July 2025 for 12 years in the Lok Sabha Parliament. And there is a serious debate on that. And no,
To resolve this, Lord, I am told, like, it was not knowledge. The Honorable Single Judge of this court, Lord, had recorded the statement of Government of India that no punitive action has
Government of
been
West
taken
Bengal.
for not singing Bande Mataram a state. Would you infringe this answer?
Yes, that is what we are saying also. Where is the punitive action
So they
taken?
say they will not.
No, no, if any punitive action has not been taken, Mr. Bhattacharya.
Has
Punitive action means you want
Has-
us a finding on that issue. We have to consider your prayer and consider. So, question: if you insist upon us that just now you decide the interim order,
No, no.
then we will hear you. We are wanting in the wake of the circumstances, the matter needs to be elaborately heard. Let him come with it.
let them file affidavit. I am not on that.
But Mr. Bhattacharya, how can we record on his behalf that I am not taking mandatory steps?
So that is his whole submission.
No, his submission is on the basis of the guideline which has been
Yes,
annexed
not-
along.
you kindly have to record that.
Yes, sir, that is already on record. That is already on record.
My lord probably is not in touch with the ground realities. That's the whole problem. But we are facing
yes.
every day with the ground realities,
ground realities.
which
মিডিয়ার
is
একটা মেয়েকে গ্রেপ্তার করে
serious and dangerous.
Nothing has been
The
annexed.
community is being fragmented. We do not know what is the consequence.
But if your lordships kindly allow me to
It is
complete
not
this,
mandatory. Anybody is willing to sing, let him sing.
will not kindly allow me to complete the sentence, your lordships will understand. 12 hours the debate was, just 1 minute. my lord.
Why you are saying in a matter, we don't want Mr. Bhattacharya in a next case, we will hear you, Mr.
Your kindly listen, this is a public interest litigation. 12 hours debate was there. And all the Muslims MPs in the parliament said, you can't compel me to sing the song.
वो तो जिंदगी भर बोले.
And ultimately, no resolution could be taken by the parliament on that day. I am not going to 1936, 1956, I am in 2025. And I can, on the next day, I can give the entire debates of the parliament. When it could not be passed through the parliament, then this is the way it is coming to for enforcement. That's exactly I am saying. And this is a serious, what Mr. Bhattacharya said, correctly it is a very serious. It will destroy the secular fabric of the country. That is the most serious thing. How can he compel it? Can a girl of 10 years in a madrasa say that no, I will not sing a song? Or 12 years, 15 years, students will say. Therefore, I am not saying anything more. If Mr. Bhattacharya is arguing everything, he will argue. Just I am assisting your lordships with this. And I will give the entire debate. 12 hours debate was there. Could not pass any resolution.
My lord will kindly pass order whatever the Lordship feels.
Swami sir, but my lord,
To pursue the honorable judge's conscience. Now it's up to the honorable court. I would like to get the matter hard on merit in particular date.
Mr. Bhattacharya, that then let it not be seen that we are not answering your,
No, not at all.
that we are not answering,
No,
we are not facing your argument.
Milord, I am more than 100%, Milord, sure about myself that the courts are quite open. No difficulty. And this is the matter, Milord, I would like the honorable court to go into in detail. Because, Milord, we are in a constitutional democracy. We are not in a, Milord, hypocritic democracy. That is the basic issue. Right, take it up.